say that was an excusal for cause on, I assume, a defense motion. Am I correct on that defense motion? That's kind of the way we have been operating as a code so that we aren't openly challenging the juror in front of them. That concludes the number of jurors we have today. 8:15 tomorrow for decisions on the motions. We'll start with jurors at 9. I think, I'm not sure, have the parties filed their briefs, because it was closed business today that I expected any briefs, so that I have something to read tonight.
I think they're all filed at this point, Your Honor.
Okay. As long as they're filed, I can find them.
Not sure about the status of ours, but.
Okay.
And I would like to make a record to address a point that was raised by defense counsel earlier.
Sure. You may.
And it's a record, and it's really a request, and that is that we proceed just kind of collectively with some caution before making assertions regarding things that are happening outside of the courtroom. I think that sometimes we're very quick to react to information that may or may not be accurate. And I think, Your Honor, that is something that happened today. I did request just a little bit further information regarding what counsel indicated was a press conference held by the city of Minneapolis in which they discussed the settlement. And I don't believe that, as portrayed, that was accurate. And what I have, and if the court's permission, I could provide to the court as a court exhibit a transcript from the Minneapolis mayor's weekly press briefing that I believe counsel was referencing. And I think that it will put into exact context what was said. First of all, this was not a press release or a press briefing that was called to discuss the George Floyd case, or a briefing about, or a press conference about the settlement. It was the weekly press briefing that the city of Minneapolis always has. And there were, in response to some questions by reporters, references made to the settlement, and specifically in which the mayor basically says, we're not going to be discussing anything about the ongoing criminal proceedings. And so
that wasn't the problem. It was that they were talking about the civil settlement.
That's right. And the civil settlement, Your Honor, and if I may I provide the court with the transcript of the actual briefing?
Is it a transcript of what was said?
It is, Your Honor. I believe this was prepared by our office, so it's not an official transcript in any way, but it could aid you in listening
Sure.
to the information that's contained in the URL that's listed at the top.
Any objection to that, Mr. Nelson?
I have not received a copy, so if the state has a copy for me to as well.
Certainly.
Because I assume you made that record earlier, Mr. Nelson, as in support of your motion to continue or change venue.
Right.
In that, specifically, Minneapolis city officials continue to talk about the case.
Correct. And it was, I mean, in the context of how it's being reported, is that the Minneapolis city attorney has specifically said that the timing of the George Floyd lawsuit settlement reflected a need to act fast.
All right. I'll accept the transcript as an aid to the actual press conference, which apparently I'll add to my nightly homework list. And we'll consider that exhibit to be part of the court exhibits for the defense motion to continue the trial or change venue. So we'll receive it as such.
Okay.
You can just give it to Mr. Schaefer. He'll mark it as court exhibit 1.
And then I would also ask, Your Honor, again, just emphasizing the importance of maintaining an accurate record. To the extent that the court is going to be relying on anything, I mean, off-the-cuff comments about something that someone may have reported in the media, that's really third-hand information. I think that if counsel is going to be making factual assertions, they need to be made as either a formal offer of proof or a declaration with supporting exhibits attached. And I don't think that the court has limited in any way defense counsel's ability to file articles, newspaper articles, or whatever kind of accounts he thinks is going to support his motion. But just simply in the middle of proceedings saying, hey, I heard that the city council is talking about this case again, without the context in which it's being spoken about, is just unfair.
Let's just stop right there. As an officer of the court, Mr. Nelson was noting something that was in progress almost. He has the right to do that. You have a right to criticize it as not being sufficiently supported by declarations and affidavits. My response to his declaration was to say it was noted, nothing more, no findings. And I would expect that he follows it up with perhaps some filings. I cannot expect Mr. Nelson to step out of these proceedings, where we've been in session since 8:30 this morning, to file affidavits to add to his record on a motion I'm going to be reading about and deciding tonight for tomorrow morning. I don't think it's fair to criticize either side. Either side. You should not be criticizing each other for noting for the record things that are happening in an emergent manner. It should be followed up. I agree with a good record is much better. But for an officer of the court to make a notation, he's entitled to do that. Whether he wants to just rest on that is fine. I think your answer to give me that transcript and a URL to listen to is also very appropriate, very important for me to look at these questions. But let's recognize the fact that the state has a lot of lawyers on this case who can sit outside this courtroom and start grinding out things. Mr. Nelson does not have the same level of support. How many lawyers now are admitted pro hoc vice and are working for the state on this case so far, Mr. Slisher? Is it 10, 12?
I don't have that number, Your Honor, but I do know that the Police Federation, the union, is funding the defendant's defense, and they have...
Let's not talk about that. We're not talking about how things are funded. I'm just saying, I can understand why what I'm saying is, I can understand why the state is able to produce affidavits and memos so quickly, because there are a lot of lawyers working outside this courtroom. I can't expect that Mr. Nelson would walk in this afternoon with affidavits when we've been in jury selection all day.
And
I think what we're getting into is criticizing each other's performance. Let's not do that. You do your own performance, you let the court evaluate whether it's enough. We're going to go forward, make your record, make it as good as you want to make it. I'll decide based on the record that's before me, and if it's not good enough, I'll say so. And to be honest, I'm not going to talk about this second press conference. I'm not going to talk about it. Make your submissions. I prefer now they be in writing, and we stop talking about it. I've asked Minneapolis to stop talking about it. They keep talking about it. We keep talking about it. Everybody just stop talking about it. Let me decide what the ramifications are. Are we clear on this? We're adjourned for the day. Submit your additional submissions in writing, not oral. Thank you. 8:15.